It is not possible for us to do everything ourselves. And this is the reason why we need to appoint agents to do work for us and on our behalfs. Today we are going to talk about the law relating to agency under the Indian Contracts Act. To start off, the most simplest form of an agency is a power of attorney. So several times we cannot do things ourselves, which is why we issue a power of attorney appointing somebody else to do something or some duty or perform some task on our behalf. Let us therefore understand the essentials of agency. Section 182 of the Indian Contracts Act defines an agent as a person employed to do any act for another or to represent another in dealings with third persons. The person for whom such act is done or who is represented is called the principal. And the person who is appointed is called the agent. Now let us take this and dissect this for the purpose of understanding. This clearly states that when a person appoints another to represent him, or when a person is appointed or employed to perform some task or to act or to represent another person or for and on behalf of the other person, this person is an agent and the person so appointing him is the principal. Moving to the next part, we understand how a contract of agency is created. A contract of agency is created either expressly or impliedly. Either by an expressed written contract. The classic case of a power of attorney drawing up a document is an expressed contract, and otherwise by conduct it could be implied. Let us now understand the essential elements of a contract of agency. Firstly, there should be a contract or a legal relationship of agency, a legal document or an implied contract creating a relationship of principal and agent. The contract may be either expressed or implied as discussed earlier, but there needs to be a contract, there needs to be an agreement where the principal creates an agent. The appointment of an agent is essential. Now another very crucial essential is the legal capacity of the principal. The parties to a contract, as we've discussed in one of the earlier videos, I'm going to post that link in terms of the essentials of a valid contract in the comments below. The parties to a contract of agency need to be competent within the meaning of the Indian Contracts Act. The legal capacity and the competence of a person, of the principal to appoint the agent, is of paramount importance. And lastly is the concept of the authority conferred upon the agent. Now expressed or implied, whichever the way the contract is, it is necessary that the principal confers the authority on the agent to act for and on his behalf. Otherwise, the agreement defeats its purpose. Another very essential element that goes hand in hand with this is the concept of ratification. Ratification is very crucial in agency because ratification means the principal agrees and confirms whatever act, deed or work is done by the agent for and on his behalf. Another very interesting question that pops up with the law of agency is sub-agency. Can an agent delegate his powers to somebody else to perform? While the agent can't appoint servants or professionals or people to do work specifically for a limited purpose, like the appointment of chartered accountants or lawyers, the agent primarily cannot create a sub-agent. This is governed by the Latin maxim of delegatus non potest delegere, which means a delegatee cannot further delegate. This simply means that if you are an agent, you are specifically appointed and your relationship is one of trust and confidence with the principal, you cannot sub-delegate your duties to somebody else. Very simply, what are the duties of an agent? Let us quickly run through these. Like we just mentioned in terms of a delegatee not being allowed to delegate, since the relationship of an agent is based on trust, it is the duty of an agent not to delegate powers issued to him by the principal. Another very interesting thing is what we would call acting with proper skill or with due diligence, or simply as a man of ordinary prudence would act. A person of common understanding would act in the present circumstances. It is further important to understand, and this is the next thing, that when you are acting for the principal, it is essential that you are acting for him and on his behalf, which means you need to follow, the agent needs to follow the instructions and the directions of the principal. Agency is a matter of trust, and this brings us to the next duty, which means an agent is obliged and is under duty to render proper accounts to the principal. Very important, when handling monies or payments of the principal, it is important that the agent provides accounts to the principal. Communication with the principal is also important because there needs to be regular communication between the agent and the principal, not only for direction but clarification, and of course, since the agent is acting for and on behalf of the principal, it is essential that they communicate and the principal is well aware of what the agent is doing on his behalf. This means that the agent would not act as if it is his own. He is always accountable to the principal and would always act with the principal's best interest at heart. In terms of accounts and payments, it is essential that the agent always renders accounts and pays any sum of money received on behalf of the principal to the principal. This is crucial. While we just looked at the duties of an agent, let us now look at the rights of an agent. While there is no specific need for consideration under a contract of agency, the agent has a right to be remunerated. Further, the agent has the right to retain sums and the right to lien on the principal's property till his accounts are settled. Another very interesting point is the right to be indemnified. An agent is acting for and on behalf of the principal, and therefore he is entitled to the right to be indemnified by the principal for any harm, losses or damage that may be caused out of and in the course of his agency. And lastly, he has the right to be compensated for any loss or damage that he may suffer on account of the principal's neglect. And finally, we come to the last bit of the laws of agency. While we discussed how to create one, it is also essential that we discuss how to terminate an agency. Now, agencies may be of two types. There may be limited or specific purpose or limited or specific period agencies, and then there may be general agencies. Now, in cases where agencies are specifically created for a limited purpose or a limited time frame, then the fulfillment or completion of that purpose or the expiry of that time frame would deem that the agency contract is terminated or determined. However, in general agreements, in general contracts of agency, the agency is revoked, and this is of course possible both with limited purpose as well as general. An agency is terminated when it is expressly revoked to the general public and to the agent. And I'm saying revoked because it needs to be revoked by the principal to the agent. The notice of revocation needs to be communicated to the agent, and to prevent misuse, it also needs to be made known to the general public. Revocation also happens when the agent renounces the business of agency. So if there is a purpose for which the agent was appointed, and that purpose or that business ceases to exist, the agency stands revoked. When either party dies or either party is mentally incapable of contracting, the contract of agency ipso facto stands revoked or terminated. Very simply, if the principal or the agent is mentally incapacitated or either of them are no more, in such a case, the contract of agency stands terminated. Now, understanding mental disability is extremely crucial. Why? If the principal is not of sound mind anymore, from the date he is known to be of unsound mind, the agency stands terminated or revoked for the simple reason the principal needs to ratify the acts of the agent. The agent is acting for and on behalf of the principal, which means if the principal is incapable of forming his or her own decision, he or she is incapable of ratifying an act of the agent. The other part is, if an agent is not of sound mind anymore, he is incapable of forming a rational decision for himself, how would he form a rational decision for and on behalf of the principal? And lastly, this is also covered in the essentials of a valid contract when the principal is adjudicated and insolvent. If the principal is adjudicated and insolvent, the contract of agency stands terminated. With this, we have largely covered the concepts related to the law of agency and contracts of agency, the most simplest form being a power of attorney. We do hope you understand this, and do like and subscribe to the channel for more updates on legal issues.